They told us help was on the way. They told us the weaponization of the Justice Department was over. They lied. The self-proclaimed most Second Amendment-friendly Department of Justice in history has just presided over the execution of state sovereignty. Missouri's Second Amendment Preservation Act, the gold standard for protecting citizens from federal overreach, is dead. And it wasn't killed by the gun grabbers we expect. It was allowed to die by the people who claimed to be our allies. This is a betrayal of the highest order. The Department of Justice, backed by a judiciary that refuses to do its job, has officially dismantled SAPA. They used the Supremacy Clause as a bludgeon to tell an entire state that it has no right, zero authority, to shield its own people from unconstitutional federal edicts. And the Supreme Court? They watched it happen. They refused to hear the case. They refused to go on record. They let a disastrous lower court ruling stand, effectively handing the federal government a blank check to commandeer state resources for their gun control agenda. We are going to dissect this forensic disaster. We need to understand exactly how the federal apparatus crushed this law, why the Supreme Court's silence is a dereliction of duty, and why the current Department of Justice is popping champagne over a victory that destroys the 10th Amendment. This is not just about Missouri. This is a warning shot to every red state in the Union. First, let's establish what the Second Amendment Preservation Act actually was. Passed in 2021, SAPA was a legislative firewall. It operated on a simple constitutional principle. The federal government cannot force the state of Missouri to enforce federal laws. If the ATF wants to raid a house for a pistol brace or a solvent trap, they can do it themselves. Missouri law enforcement was legally prohibited from assisting them. If a state agency violated this and helped the feds enforce an unconstitutional statute, the citizens whose rights were violated could sue for $50,000 per infraction. It was the strongest anti-commandeering law in the country. It was federalism in action, exactly as the founders designed it to check a tyrannical central government. But the Department of Justice viewed this as an existential threat. Under the previous administration, Merrick Garland launched a lawsuit immediately. That was expected. He was an enemy of the right to keep and bear arms. He argued that SAPA violated the Supremacy Clause, claiming that Missouri was attempting to nullify federal law. This is a deliberate legal distortion. Missouri never said federal agents couldn't enforce the law. They said Missouri tax dollars and Missouri badges would not be used to do the federal government's dirty work. That is a well-established legal doctrine known as anti-commandeering. States refuse to assist the feds on immigration and narcotics constantly, and the courts stay silent. But the moment a state refuses to assist in the confiscation of firearms, the Department of Justice declares it a constitutional crisis. Here is the bitter pill. We expected this hostility from Garland. We did not expect the new regime to let it stand. The current DOJ could have dropped this lawsuit. They could have sided with Missouri. Instead, they allowed the machinery to grind forward. The Eighth Circuit Court of Appeals struck down the law, accepting the government's premise that a state cannot refuse to cooperate if it interferes with federal priorities. This is a perversion of the Supremacy Clause. A federal law is only supreme if it is constitutional. As established in Marbury v. Madison, a law repugnant to the Constitution is void. If a federal gun control statute violates the Second Amendment, it is not supreme. It is null. Yet the courts ignored this fundamental axiom to protect the administrative state. Now, back to the legal nightmare. The Eighth Circuit's ruling was a disaster, but the final nail in the coffin came from the United States Supreme Court. Missouri appealed. They asked the highest court in the land to answer a simple question. Can a state refuse to enforce unconstitutional federal gun control? And the Supreme Court, the court we were told would save the Second Amendment, refused to answer. In October 2023, and again recently, they denied certiorari. They didn't rule against SAPA on the merits. They simply refused to hear the case. This is judicial cowardice. By declining to intervene, they allowed the Eighth Circuit's ruling to become the final law of the land for that jurisdiction. They let the lower courts dismantle state sovereignty without ever having to put their names on a decision. Because of this refusal, SAPA is unenforceable. The protections are gone. The $50,000 penalty for violating your rights is gone. The message from Washington, D.C. is clear. resistance is futile. And make no mistake, the DOJ is celebrating. This victory allows them to continue weaponizing local police forces against their own communities. It reestablishes the federal dominance over state law enforcement. This brings us to the most dangerous aspect of this situation: the friendly Department of Justice. We are seeing a continuity of agenda. Pam Bondi and her team are demanding that federal gun control laws remain supreme. While they might pay lip service to the Second Amendment in speeches, their actions in court tell a different story. If they were truly constitutionalists, they would have withdrawn the federal opposition to SAPA. They didn't. They secured the kill. This suggests that the federal government, regardless of who is in charge, is terrified of losing its power to commandeer state resources. They know they don't have the manpower to enforce mass gun control without the help of local police. SAPA threatened to cut off that manpower, so they crushed it. This ruling creates a weaponized precedent. The Department of Justice now possesses a blueprint to dismantle state-level resistance across the entire map. Missouri was the test case, but the target list is expanding. Kansas, Tennessee, Kentucky, Arizona, Montana, Texas. Any state that has attempted to erect a legislative shield between its citizens and federal overreach is now in the crosshairs. The strategy is clear. If they can crush SAPA in the Eighth Circuit, they will use that case law to bulldoze similar protections in every other jurisdiction. This is the nationalization of enforcement. We are witnessing a hostile takeover of the 10th Amendment. The legal question here was foundational. Does a state possess the sovereign right to refuse to participate in the enforcement of federal statutes that violate the Constitution? Under the anti-commandeering doctrine established by the Supreme Court, the answer is undeniably yes. The federal government cannot conscript state officers to act as their foot soldiers. But the lower courts, emboldened by the Supreme Court's silence, have ruled that federal priorities override state sovereignty. This is a legal fiction designed to centralize power. If this principle holds, the federal government has effectively deputized every local police department in America against the will of their state legislatures. I am going to speak directly to the men and women behind the badge, because this concerns your oath. I know this makes some of you uncomfortable, but the reality is unavoidable. You did not swear an allegiance to federal agency regulations. You swore an oath to support and defend the Constitution of the United States. When the federal government demands you enforce laws that infringe upon the Bill of Rights, you have a moral and legal obligation to refuse. The court may have struck down the financial penalties of SAPA, but they cannot strike down your discretion or your oath. If you allow yourselves to become the enforcement arm of a weaponized Department of Justice, you are no longer peace officers. You are agents of a centralized control grid. This is why the battlefield must expand. The death of SAPA is a tactical defeat, but the war is decided by cases like Bruin, Cargill, Mock v. Garland, and Duncan v. Bonta. It is decided by who sits in the state attorney general's office. If states are going to survive this assault on their sovereignty, they need legal teams that are willing to engage in aggressive, high-stakes litigation. We need organizations like Gun Owners of America, the Second Amendment Foundation, the Firearms Policy Coalition, and the revitalized NRA to hold the line. We also need to be realistic about the legislative landscape. Do not be lulled into a false sense of security by promises of national reciprocity or federal constitutional carry. Those bills are dead on arrival without 60 votes in the Senate, and that supermajority does not exist. The federal legislative path is blocked. The fight is in the courts and in the state houses. We have arrived at a decision point. Do you believe the Supreme Court abdicated its duty by refusing to hear the SAPA case? Do you believe a state has the right to tell the federal government no? These are not theoretical questions. They are the defining issues of our time. Missouri must not retreat. They must redraft, relitigate, and force the issue back to the High Court. If the federal government can bulldoze a state's refusal to cooperate, then every state is a vassal. Patriots, the warning signs are flashing red. The Department of Justice has shown its hand. They will use every tool, from lawsuits to judicial inaction, to ensure that federal control remains absolute. Stay alert, stay prepared, stay armed, and above all, stay free.